Hey, so today I interviewed Judge McGee, a really well-respected former prosecutor and judge for well over 30, 40 years, presiding over Bergen County for about 30 years. Extremely intelligent, extremely cool, extremely kind, very good tennis player. I learned a lot from talking to him. He's extremely educated, knows a lot. I really enjoyed talking to him, and, you know, I think he made a really good interview. So, he's even the judge in one of the cases of current presidential candidate Chris Christie for Bridgegate. Incredible guy, and hopefully you enjoy this interview with Judge McGeady as well. Thank you. Google Meet. So it should be recording. I also like to screen record it. So I have two recordings. All right, microphone. Yeah. Show more options, tab audio. All right, so if all went according to plan, we should be live. So how are you?
I'm good, thanks. And how are you?
I'm great, Your Honor. I'm great, Your Honor.
It's hard not to be good on days like this with this kind of weather.
Oh yeah. No, I went outside before. It's immaculate outside.
Yep.
Yeah.
Played tennis this morning.
It's good. Yeah, we talked a bit about that before the show and stuff. You're a big tennis guy.
Yeah. Play every day.
That's good. Keeps you in shape.
It does.
Does. Keeps your mind off things, relaxes you a bit.
Yeah. Of course, being retired keeps me pretty relaxed too.
That's good. That's good. So you were a judge for over 40 years and in criminal law in general for 40 years, I should say.
Yeah, not quite 40 years, George. I was a judge. Well, I became a municipal judge in 1983. And I retired in 2018. I'm sorry, 2017. So I was actually a municipal judge for 34 years. And then in 1999, I became the presiding judge, which now made me a state paid judge to supervise all the municipal judges.
Right. Right. And this was in Bergen County, right?
Right. Bergen County.
Right. So you had a lot of experience in the field and for years and years and years, and you were a lawyer too, right?
I was a lawyer. I became a lawyer excuse me, in 1968 in both the state of Nebraska and New Jersey.
It's nice. Any differences like majorly in the court systems or?
I never really practiced in Nebraska. I went to law school there and took the bar exam as a courtesy. You know, they invite you to take it, but I never practiced, so I wouldn't be able to answer that.
Fair enough. So yeah, I mean, how did all this start? I mean, you've been a judge in multiple high profile cases, you know, a lot of media coverage cases, you know, including that of a current presidential candidate. You know,
right.
How did this all come about? What's the start to finish? Like, what's the journey?
Well, that's a good question. When I first became a lawyer in 1968, the municipal courts didn't have public defenders. And yet they had indigent defendants that needed representation. So the Chief Justice encouraged lawyers to volunteer their time in the municipal courts so that in effect we'd have unpaid public defenders. We'd be assigned, we'd defend someone, wouldn't get a fee, but we'd get some experience. And the Chief Justice encouraged young lawyers especially to do it and encouraged them to do it maybe where their office was and maybe where their home was. So I did it in both Rochelle Park, where my law office was, and in Saddle River, where my home was. And for years, I represented people unpaid. And then I'm going to estimate around 1973, 1974, the legislature passed a law obligating the governing bodies, the mayor and council, to appoint public defenders and pay them. And since I had been the face of the public defender in both those courts, I was appointed to be the public defender, mostly in Saddle River, not so much in Rochelle Park. And I was having a fair amount of success as a public defender, and the police were getting frustrated because they weren't they weren't too impressed with their prosecutor. So they went to the mayor and council and asked that I be appointed the prosecutor. And they did that. So for 3 years, I was the prosecutor in Saddle River. And then, unfortunately, the judge died. So the mayor and council appointed me to be judge in Saddle River. So I'd really been in every corner of the courtroom. As public defender, I was on one side. As prosecutor, I was on the other side. Now I'm on the bench. And then in 2 successive years, two other courts, two other governing bodies reached out to me. Montvale asked me to come in and interview to become the judge in Montvale. And then Rochelle Park the next year interviewed me to become the judge in Rochelle Park, and I did. So for several years, I was the judge in three of those different towns.
What's the biggest differences, between the different careers and positions you've hopped between?
Well, I liked being a prosecutor because now you had the full force of the police department supporting you. When you're a public defender, you're kind of on your own. But when you're the prosecutor, the police are eager to help you. They gave me demonstrations on how to operate the alco test, the breathalyzer, how to operate radar. They gave me demonstrations. They were eager to help me. So you had plenty of support and help when you were the prosecutor.
And judge?
Judge, you got support and help from the Administrative Office of the Courts, known as the AOC. There's judge training. When I first was appointed, I had to go to a 2-day training session. And then there was at least once a year a statewide judges meeting, and once a year a county judges meeting. That all changed when presiding judges were appointed. In 1999, when I was appointed as presiding judge in Bergen County, this was the first class where every county had now a presiding judge, and things drastically changed at that point. The training was much more intensive. I just was looking at my notes when you and I first talked, and I see that I trained 74 municipal judges in Bergen County.
So what exactly would you do in a day? What would, from your morning to what would that look like?
The training session, generally, I would meet with them one-on-one and give them a 3-hour lecture on how to be a judge. And then I would require that they come and sit with me in one of my courts and watch me through a whole court session. And then only then were they allowed to actually sit and start judging cases themselves. And then one of my other jobs was to go out and visit. We had 72 courts in Bergen County. So I was the busiest presiding judge because that's the largest number of courts in any county, 72. I think Monmouth is next, and they have only 52. So I would go out to the various courts and sit there and watch the judges, not to intimidate the judge, but to supply useful criticism, which I would never do while court was in session. I wouldn't embarrass the judge, but I would write up a report and send it to him, and then I would talk to him or her by phone and make some constructive suggestions.
So on a daily basis, on a regular day too, what would that usually entail of just being a judge?
Well, again, it changed over the years. As a municipal judge, you're allowed to have a law practice still because a municipal judge appointment is only part-time. So in the beginning, when I first got the Saddle River appointment, I still had a very active law practice. And then I got the Montvale appointment, and I got busier in the municipal courts, and that gave me less time for the law practice. Then the next year I got Rochelle Park, so I'm now sitting in 3 courts, less time for the law practice. When I became presiding judge, I still practiced law for a little bit, but it was pretty clear between my duties as presiding judge and my duties in those 3 municipal courts, I didn't have very much time for the law practice. So I eventually closed down my law practice and served full time as a municipal and state presiding judge.
And I just want to confirm this municipal is like a town judge, right?
It's
Or
a
like,
town judge, and the judge is paid a salary by the mayor and council, or the municipal government. As presiding judge, I was paid a salary by the state of New Jersey, and I was appointed by the Chief Justice of the Supreme Court.
so you were appointed by someone in the federal Supreme Court or the New Jersey Supreme Court?
No, the New Jersey Supreme Court, George.
All right. Yeah. So, I mean, that's really incredible. So, how long in total did you do all of this? Like in a span of how?
Well, as a judge, 34 years totally, but the last 18 of those years, I was both a municipal judge and the state presiding judge.
Right. So the presiding judge is basically like the director of the other judges, or?
That's a good. I called it a supervisor. Some of my colleagues call it a coach. Kind of the boss, but it really wasn't that kind of a situation. It was more of a person to guide and teach judges. Several of the judges ultimately became Superior Court judges, and they referred to me as their mentor.
I think that's a pretty good term for it.
Yeah.
Yeah. I mean, was there any? So the main difference was just that between presiding judge and a regular judge would just be that essentially you were just coaching these people and guiding new judges.
Sort of. I mean, they looked up to me. They knew I was their boss. They would say that they would make a decision, and they would worry about how I would look at their decision. Here, excuse me. Phone's ringing in the background. My wife's getting it. We're done.
All right. Yeah. So, yeah. And as for the time that you were a prosecutor, what would that look like on a daily basis?
It wasn't so much on a daily basis. Most of the courts met anywhere between 2 and 3 times a month. Montvale met 4 times a month. So usually the weekend before I had a court session, I would read all the statutes that I knew I was going to have to be involved with in prosecuting. And I would prepare the cases. I would have copies of the summonses. So I knew what I was expected to prosecute. And I would do the preparations on the weekend. And then on the actual day of court, most of them started in the evening in the early days when I was first a municipal judge. But the tendency later on became to move them into the regular workday. So a lot of the court sessions started at 1 o'clock in the afternoon. So I'd go to my law practice in the morning, and then the court right from the law practice.
So I have a question now about your career as a judge and a lot of the decisions you made. Was any of it ever based off of, your judgments? Were they ever based off of, the appearance of the person?
No, not as a judge, never. Although I can tell you that when I tried as a lawyer, my very first jury trial, I was representing, this was in 1970. I was representing some young people with long hair. We would have called them hippies in those days. And I remember being very concerned that the jury would not be very accepting of their testimony and everything. So I remember during the voir dire, which was the preliminary questions that you get to ask a juror before they're accepted as a juror, I remember being concerned about whether the jurors would be affected by their appearance. But as a judge, we're trained to really judge things on the evidence, not on appearance.
So did a defendant's, attitude or punctuality ever influence things, or?
2 different answers on that. Attitude, yes. 2 of the things that I had to do as a judge, one was initially during an arrest, I had to decide whether to release this person on bail or keep them in jail, even though they're presumed innocent until we get to the trial. And I can remember saying to some wise guys, look, I got about 2 minutes to decide whether you're going to spend the next 6 months of your life in jail waiting for trial, or whether you're going to be home sitting in your living room waiting for trial. How you act in those 2 minutes has a lot to do with how I'm going to decide which of those two options to do. So yeah, they're being a wise guy and not giving me the answers that only they had that I need to know to see if they're a flight risk or see if they're a danger to society. In that case, attitude could affect them. In the other case, sentencing, when I'm doing a sentence, if I don't see some remorse, some contrition, some sorrow for what they did, I would consider that, because I have sentencing options, and I would consider that attitude in the sentencing. As to punctuality, I never would let that make any impact on my decision, but this used to anger me. I'm a very punctual person myself. And if I had a special trial session scheduled for 9 o'clock in the morning, where I was giving up my own time from my law practice, and the lawyer shows up half hour late, even if the defendant was there, we can't move to trial without the lawyer. I would say to the lawyer bluntly, I'm the judge that's going to hear your client's case, and you're going to keep me sitting here cooling my heels for a half hour, trying to embarrass the lawyer. But then I would assure the client, this has nothing to do with how I'm going to decide your case.
Have you had many flight risks that you've had to decide on, or?
Yeah, and there's a lot of factors. And again, I keep saying this to you because in the 34 years that I was a judge, so many things have changed. But in the earlier days, we would look at the severity of the offense and the potential sentence, and then you would look at the defendant's contact with the community. Did they own a house here? Did they have a job here for a long time? That showed that they're probably not going to take off some way, because they had a lot to lose. And also the severity of the offense. If it was a minor offense, they're definitely not going to take off. It's a more serious offense where they're going to go to jail, then they may more likely take off. So you looked at those two factors, the seriousness of the offense and the contact to the community. Later on, I became the head of something called the Central Judicial Processing Court. That was part of my job as the presiding judge. The Central Judicial Processing Court was one court. Instead of, let me backtrack and say, in the old days, if you were arrested in Saddle River, you came before the Saddle River judge who set the bail. When we established the Central Judicial Processing Court, no matter what town you were arrested in, you came into the Central Judicial Processing Court before me, and I made a decision as to whether you were going to sit in jail or whether you were going to go home. And I was given something called a public safety assessment, which was very helpful. It was, we had a staff that would go and interview the person in jail when they were arrested last night. Then we'd interview them in jail in the morning, and then they would put the answers to those interviews into a computer. And a survey had been taken, and it found that there were 9 factors that really indicated whether a person was likely to flee, or likely to commit another crime, or likely to commit a serious crime. And so they put those answers in the computer, and the computer would spew out a report to me. And it gave me 2 pieces of information. It gave me what's the term? A list, or not a list, between 1 and 6, continuum. That's what a continuum between 1 and 6. 1 being the least chance of fleeing, and 6 being the highest chance of fleeing. On fleeing, and then they gave me a 1 through 6 continuum on the likelihood that they'll commit another crime. 1 being the lowest, 6 being the highest. So if you came in front of me, you didn't want to be a 6 and a 6, because it looked like you were probably going to run and you were probably going to commit another crime. In those cases, they'd sit in jail. If you were a 1-1, you were probably going home. in between, we had various options. If, say, they were a 3-3, I would say, okay, you can go home, but I want you once a week to call the probation department and keep in touch with your probation officer. And then the following week, I want you to personally show up in the probation office. And then the following week, you make a phone call. And then the week after that, you go personally. So we could set all kinds of variations. One of the things I could do is make them wear an ankle bracelet. Okay, you can go home, but you got to wear an ankle bracelet. You can only go to the doctor, to work, and to your lawyer's office.
This reminds me of something. There was a study, it's kind of a famous study, which I don't remember the university was done, but basically said that before and after lunch, there's a difference between the way that a judge would sentence, do probationary sentencing, right? And immediately after a judge had eaten, they would have a better likelihood of getting parole. That was the determining factor, the time period of when they had a break. Do you think that's true, or?
I've never sensed it myself. No, I can't say that I ever felt any differently between morning or afternoon.
Yeah, it just reminded me of that. Did you ever feel any political pressure from the person or city council that appointed you?
Yes. And that's a problem that we struggle with. And it's a problem that I've worked on personally to try and avoid. The mayor and council appoint the judge. The judge is appointed for 3 years. Judge wants to be reappointed. Usually the judges like the status and they like the job. So they want to keep the mayor and council happy. What keeps the mayor and council happy? Finding a lot of people, a lot of money, and those monies go partly to the town. So there were judges that abused that. And it was my job as their presiding judge to make sure it wasn't being abused. And yes, I had gotten subtle inquiries indirectly, never mayor and council directly to me, but they would go to my court administrator and say, gee, we see that the revenues are down. And very often there were many different answers for that. It was a short month. The police were having negotiations for their salaries and they weren't happy with the way it was going, the mayor and council. So not so many tickets were being written. There were a lot of factors. I just had to make sure that it wasn't a judge factor.
So for the most part, you'd say you kept everything as unbiased as you could, and you remained as objective as you possibly could.
Yes, we had a motto: fairness, quality service, integrity, honesty.
Right. So now I got to ask you this. Did tennis help you at all?
You know, that's an interesting question. Tennis, I see a parallel between the discipline to be a tennis player and the discipline to be a judge. So to that extent, I would say that there's commonality. However, my father was a very disciplined person, and I'm not sure I can separate the gene portion from it, that I inherited his genes, from the fact, the tennis portion of it. But there's certainly a consistency there. Tennis probably helped me more as a lawyer because I was very competitive, and as a lawyer, you got to be competitive.
That makes sense. That's fair.
Yep.
Did it ever relax you at all, or keep you focused, or?
The tennis? Probably the opposite. If you're playing a tournament, it can get pretty uptight. I mean, when I play a social match, yeah, it's relaxing, it's fun. You bond with the people you're playing with. But when you're playing a tournament, it's not relaxing.
I think that's fair. I think that's with any sport, though.
Yeah, that's true.
You ever keep statistics as a judge?
George? This book is all statistics. All statistics. I kept statistics on everything. I tried 4,189 trials. I know I sat in 3,800 court sessions. I heard 75, I think, drunk driving trials. Yeah, I've got statistics on everything. I heard 600 domestic violence restraining order applications.
That's fair. I think that's it's a pretty good amount. Is it common for judges to keep statistics?
No, it's not. I was probably the only one that did it, but I found it helpful. When we were comparing notes between judges and how many restraining orders were granted and how many were denied, I was glad to have my statistics and know the exact answer for me.
What's probably like the craziest statistic that you have?
Probably the fact that I tried a 32-day trial, from 9 o'clock in the morning to 4 o'clock in the afternoon. That's unheard of in municipal court. I don't know of any other trial ever anywhere in the state that's lasted that long in municipal court, certainly in Superior Court. But I think that's the longest that I know of.
That's pretty wild. So for 32 days straight, or
No, there were often witness problems, witnesses not being available and stuff. So we'd do maybe 1 or 2 days a week, and then go over to the next week. So the 32 days may have lasted 3 or 4 months.
so it's not common for trials to last that long.
No, certainly not. And none of the Bergen County municipal judges wanted this case. There were various reasons why several of them couldn't do it. So I said, I just got to step in and do it.
Ever work on a federal case or anything of that sort?
Not as a judge. As a lawyer, I can remember appearing in federal court. I represented a guy who was a trucker, and he was delivering hand grenades. And for some reason, he didn't get paid by the federal government. So he was holding the hand grenades back at his trucking firm. And the U.S. attorney filed a lawsuit to compel him to turn the hand grenades over. And I was representing him, resisting it. I think we eventually settled it. It was a long time ago. But yeah, so I appeared in federal court on it.
So the U.S. Attorney of New Jersey or the U.S. Attorney General?
U.S. Attorney of New Jersey, the position that Governor Christie used to hold before he was governor. But it wasn't him, it was his predecessors.
What are the U.S. attorneys like as compared to a regular district attorney?
I don't really know. I don't have much to do with the U.S. attorneys other than this one case. So, you always wonder, they're politically appointed, but that doesn't mean they're not good.
Yeah, of course. So that's really the only federal case you had to deal with, or were there others?
That's the only one I recall dealing with. I mean, indirectly, I'm always dealing with the federal government to the extent that the federal Constitution has to be applied in my court. So even though it's a municipal court, if I find something violates the Fourth Amendment of the United States Constitution, I grant a motion to suppress. So there's always the connection between the federal government and the state and municipal government. But as far as the actual federal courts and federal U.S. attorneys or federal public defenders, I didn't have much dealing with.
So, and I want to switch this topic now to one of the more famous cases that you've dealt with regards to Governor Chris Christie. So, he's currently a presidential candidate. He's ran multiple times. And many years ago, he was in this case called Bridgegate, as it's popularly coined. What exactly was that? And just give an explanation.
Sure. Bridgegate was Governor Christie's administration, and this is clear cut, decided to obstruct traffic near the George Washington Bridge in Fort Lee. And they knew that that would create chaos. They wanted that to happen because they wanted Mayor Mark Sokolich, the Fort Lee mayor, to support Governor Christie in his run for re-election, and he wasn't doing it. So this was payback, and that was called Bridgegate.
So it was basically extorting, or trying to get revenge. I guess the right term would be extortion against a political, not adversary, but friend, more or less.
Yeah, someone who the governor wanted him to support him, and he wouldn't do it. So it was retribution.
So let me ask you this: and this is something that you're very well known for on multiple news articles, is that you made the decision to continue the investigation of misconduct claims against Christie. What exactly inspired you to do that?
Well, it's sort of true, George. We have court rules in New Jersey that tell us how we have to do things, and one of the court rules, Rule 7:2-2, says that whenever a private citizen, George, signs a complaint against someone, it has to come before a judge for a preliminary examination. And the reason for that is, you can imagine a disgruntled taxpayer. Governor Christie raises taxes, and the taxpayer is disgruntled, so he files a harassment charge against Governor Christie for raising taxes. Governor Christie would be traveling all over the state defending himself, not have time to be governor, and it would be ridiculous. So they require that this private citizen complaint come before a judge for some kind of a screening to see if there is some legitimacy to this complaint. It's called a probable cause hearing. Probable cause is a confusing term. It basically comes or means this: when the United States Constitution was written in 1776, people talked in a different way than we talk now. People would say, I have cause to believe that he did something. And cause in those days meant reason. I have reason to believe. Probable cause means more likely than not, there's a reason to believe something. That was my job, to decide whether it was more likely than not that there were reasons to believe that a law was violated by Governor Christie. That was what the probable cause hearing was about. And the way I got it, there was in the federal courts, two of Governor Christie's employees, staff members, were being tried. William Baroni and Bridget Ann Kelly were being tried for causing this traffic jam. And a fellow named Bill Brennan was running for governor, not against Governor Christie, because Governor Christie was in his second term at this point by the time the trial occurred. But this fellow that was going to run for governor, Bill Brennan, sat in on the Baroni and Bridget Ann Kelly trial, and he heard testimony at that trial that led him to believe that Governor Christie, while he may not have ordered the traffic offense, that he later learned, because the traffic continued for about 3 days, that somewhere in the middle, the second day, he learned about it, and he failed to take steps to end it. And that therefore that would be misconduct in office. So Bill Brennan made a complaint against Governor Christie for misconduct in office. It's a private citizen complaint, has to be heard before a municipal judge. Because the offense took place in Fort Lee, the Fort Lee judge would have normally heard it. But the Fort Lee judge was appointed by Mark Sokolich, the mayor of Fort Lee. So the Fort Lee judge was a very wise judge, and he recused himself. He said, I can't hear it. So because it was so sensitive, they sent it to me.
And your ultimatum was?
Well, it was a tortured, decision. When it first came in front of me, the testimony of a fellow named David Wildstein had occurred in the federal court. David Wildstein was known for dirty tricks. He had a nickname called Mr. Edge. He wrote a I don't know, a magazine or something, or a periodical talking about it. And he was referred to as Mr. Edge in that magazine. He testified that he and William Baroni went to a September 11th memorial service down at the World Trade Center. This is well after the September 11 tragedy. And they saw Governor Christie, and they wanted to keep him happy, and they wanted him to know that they had caused this traffic to occur in Fort Lee so that the Fort Lee mayor would be punished. But they talk in political speak. Nobody says, guess what, Governor Christie, we created a traffic hazard and traffic jam in Fort Lee to get back at Mayor Sokolov, Mayor Sokolich. So they said, they did it in a veiled way. They said, there's a lot of traffic in Fort Lee, Governor. Oh, Governor says, yeah. And the mayor is calling us all the time. He wants to talk to us about it. Oh, and we're refusing to answer his phone calls. I wouldn't imagine you would answer his phone calls. That's what the governor said. And well, David Wildstein's in charge of all this. Mr. Edge is taking care of it. Okay, good. Everything goes through Mr. Edge. So all of those conversations led me to believe he knew what was going on, and he didn't take the steps necessary. He had a lawyer who ultimately became Governor Christie's U.S. attorney successor. His name was Craig Carpenito, a very good lawyer, a very polite lawyer. And he wanted me to allow him to cross-examine Bill Brennan, who was testifying in this probable cause hearing. And I wouldn't let him. I said, no, this is a private hearing. It has the governor's not even a defendant yet until I say he's a defendant. So you don't have any standing. This is like a grand jury hearing. You just don't have the right to be involved in it. So I didn't allow it. He appealed my decision because he wanted to cross-examine. And I got reversed. The appellate court said, no, you should have let him cross-examine. So they sent it back to me. So now we go through this a second time. But by this time, not only did I have the transcript of David Wildstein's testimony from the U.S. District Court, since then, Bridget Ann Kelly testified in her defense, and I now was given her a transcript of her testimony. And her testimony was even more conclusive. She was saying things that nothing happens that Governor Christie doesn't know about or doesn't approve of. And she pretty much corroborated what Baroni and what Wildstein said. So now I had even more conclusive evidence, and I ruled that there was probable cause, which simply meant that I was issuing the summons and that now the governor had to stand trial for the charge. But in the meanwhile, between the first and the second hearing, the prosecutor, who had just been appointed by Governor Christie, was wise enough to say, I can't be involved here because I was just appointed by this governor. So he put his next person below him in charge, the first assistant prosecutor. And that person said, no matter what Judge Mcgeady does, we're going to dismiss this complaint. So it would have been easy for me to say, okay, it's not going anywhere. I might as well just dismiss it. But I felt that wasn't my job, wasn't the scope of my responsibility. So I said, I don't care, knowing what's going to happen, I'm still going to decide this case. And I decided there was probable cause and that he should stand trial. and I'll leave it up to the prosecutor's office to decide what they're going to do. And they immediately dismissed it. And I don't disagree necessarily with their dismissal, because we're dealing with two levels of proof. Remember, I explained to you before what the probable cause level is. The prosecutor has to decide whether they can prove the case beyond a reasonable doubt, which is a very high standard, the highest standard we have in any court. So I'm not disagreeing that they maybe couldn't prove it beyond a reasonable doubt, but I felt there was probable cause.
So all the witnesses basically told you, Bridget and Kelly especially, basically, they all claim that there's no way that Chris didn't know what was happening, and that he likely orchestrated it to some extent. And you agreed as well that it's more likely than not that that was the case, and in the end, it just got thrown out
By the prosecutor, yes.
All right. Did you feel any pressure from the media or?
No, no. I mean, I knew the media. The media was they practically shut down our office when I made the first decision. All kinds of phone calls were coming in. My staff was going crazy trying to deal with them. But I didn't feel any pressure. In fact, when I did the second hearing, almost the whole courtroom was packed with media. It was standing room only, and most of the people were media. And after I made the second decision, this surprised me. There was an eruption of applause. Now, I didn't do it for that. I didn't know it was going to happen, nor did I know what the media's position was. But I found it surprising that the media was prepared to so publicly show its approval of the decision.
So the media agreed with you as well, correct?
Yes. Well, certainly the media in the courtroom did.
And the witnesses as well. But, and I don't expect you to know this, but what exactly do you think then, if everybody was agreeing generally on your side of things, what exactly do you think was the issue with the prosecution team? The proof or?
Yeah, I think they felt that because there wasn't the actual conversation, yeah, Governor, we're disrupting traffic on your behalf because we're getting revenge against Mayor Sokolich. Because that language wasn't used, they didn't feel they could prove the case beyond a reasonable doubt.
So in essence, their language was too easy to interpret in different ways.
Correct. And that that perhaps the jury would find reasonable doubt and just dismiss the case. And it would probably be an extensive case. The federal case was an extensive case.
So essentially the burden of proof was just too hard to come to.
You got it, George.
All right, that makes sense. Yeah, so now switching to another topic, this being personal cases, stories, and defense attorneys. You ever have a defense attorney that just really, really impressed you out of the gate and just in general? You know, who was it? Why did they do it? Or
Yeah, sure. It's a dangerous area to get into because there were so many that I thought were good. And so to say names is a little tough, and the reason I'll mention a couple of the names, but mainly because they were good, but these were the ones that most frequently appeared in front of me. So they're at the top of my head. But Joseph Rim, Ray Flood, Bob Galantucci, all good lawyers who appeared in front of me often and frequently. They were very respectful, but very prepared and just very successful often. Andrew Sampson and Tom Hanratty were two prosecutors I had that were excellent. Someone you know, Alan Peyraton. Alan was a young lawyer, new, and he just had a passion for learning. He would come and sit in my courtroom. He was my public defender for a short time, and we would discuss for hours legal issues and things. He just had a passion to learn.
so was there any that and this one you don't have to mention names, but was there any like things that maybe not even necessarily these attorneys did, but there was just a defense attorney that really impressed you?
Impressed me? Those are the ones I just talked about. I think you may be asking me about ones I didn't like.
No, like a story, like a case of a defense attorney that really impressed you, like in terms of their defense that they came up with, or just something.
They were creative. I'll say that. John Bruno and Kevin Rowe were two good defense attorneys that had very novel approaches to things. I can't give you the specifics only because I don't remember now, but I remember thinking that about them. Uh-oh, this is going to be something new because one of these two attorneys is here.
I'm going to ask you one that my uncle told me to ask you, that being, what's maybe the weirdest or funniest case you ever presided over?
Well, I can answer that two ways. I used to keep notes on some of the humorous things that happened in the courtroom. One of the things that we had, you may remember these, George, we had red light cameras at intersections. So that if you went through a red light, the camera would record showing your car crossing the white line, the light being red, could see your driver's plate, your license plate, and could see your face. From all those things, the staff could find out who you were, and they would prepare a ticket and a bill for $80 for going for speeding, and they'd send you a photograph. So they'd send you a photograph, a ticket, and a bill for $80. So one creative defendant sent us a photo of four $20 bills. Our staff, not being one to lose, sent him a photograph of handcuffs. And the next thing we knew, the check came in. Other things, people would get nervous when they'd come to court, and they would use malapropisms, wrong terms. One of the terms that we use a lot is plea bargain. So I've had defendants come in and say they wanted a flea bargain. We had a drug program called conditional discharge. And I had one defendant who wanted a traditional discharge, not a conditional. I had a fellow ask me for an adjournment because he had to take his wife for a breast autopsy. I think he meant biopsy. I had one defendant who told me that the police compounded his car. I said, really? I think he meant impounded his car. I had a dyslexic secretary who would send me an order, and wanted me to sign it, but she accidentally misspelled it and put S-I-N-G instead of S-I-G-N. She asked me to sing the order. She hasn't heard my voice. I had a fellow I was sentencing. I asked him what he did for a living. He said, I work in a car wash. I said, what do you do? I sodomize cars. I think he meant simonize. Someone asked me about if he could take a lie detector. I said, I'm a lie detector. I don't like lies. And then lastly, I have one here. This one person was trying to impress me with how smart he was. Says he has a pornographic memory. Those are just a couple of the humorous things I saw in court.
You ever have any really creative defendants? Like people that tried to get away with stuff just really creatively?
No, not so much creatively. It was usually, the red light, the cop said the light was red. They said, no, it was yellow. That was the back and forth, and it could boil down to credibility. Can't remember any really creative defenses. I can remember an odd case. There was a police officer. He was part of a training session at the police academy in Mahwah, and they were demonstrating the ALCO test, which is the breath test for drinking and driving. So they asked for a volunteer police officer to drink alcohol so that they could test him and show how it worked. So they did. And of course, he got drunk, and another officer drove him home after the session was over. Now they're at the drunk officer's house, and the drunk officer decides he's going to go out on his moped, even though he's drunk. He goes out on his moped and flips the thing over. So the town was the police in the town that he lived in charged him with drunk driving, and that came in front of me. I thought it was kind of humorous that he was teaching about drunk driving, and now 5 minutes later he's in front of him.
Best example of irony.
Yeah.
Yeah. Ever have any cases where the defendant just did something really strange, like it wouldn't make sense, but like to you to even commit the crime?
Yes. The state attorney general, her name was Zalima Farber. It's all public record, so I can say her name. She had a boyfriend. His last name was Gore. I don't remember his first name. And Mr. Gore got stopped by the police because they did a check of his driver's license and found it to be suspended. So they were going to charge him with driving on the suspended list or license revoked list. Mr. Gore had the poor judgment to call his girlfriend, the attorney general, who then showed up at the scene with the state police car and tried to influence the local police to not issue the summons against Mr. Gore. They weren't successful. So now the case comes in front of me, the Mr. Gore case. The attorney general wasn't charged with anything, but Mr. Gore was. So his case came in front of me because it was politically sensitive. But the papers and the media had picked up on the fact that the attorney general had tried to influence the police to not issue the summons to her boyfriend. And then her boyfriend went to the Division of Motor Vehicles before the trial occurred to try and straighten out the driver's license. And he was given special treatment. You've probably been to the Division of Motor Vehicles. The lines are usually very long, but somehow he got right up to the front line. And I remember the record showing a political cartoon of a DMV with a long line of people waiting and a special line for friends of Zalima Farber. So the case came in front of me, and a month before trial, we set a special date, and the defendant was in court and he heard the date. And whenever a defendant is in court and specifically gets an in-court date setting his trial date, he's on notice of when to be here. So now the trial comes up a month later. And in the meanwhile, because of media and political pressure, Zalima Farber resigns from her position as attorney general. She wants to just get out of here because there's so much attention to this. So the two of them go to Mexico for a vacation. He doesn't show up at the trial. Because he had received the in-court date, I said, okay, the courtroom was packed. We're going to try the case in absentia. It turned out that he wasn't suspended. I found him not guilty, but I charged him with contempt for not showing up in court. And I imposed some sanctions on him, and his lawyer appealed that, and I got reversed on the grounds that any defendant is allowed to voluntarily absent himself from the trial.
So in essence, it was just way too much effort for a crime that really wasn't that big of a deal.
That's exactly right. The consequences were so great to the attorney general for something that really didn't exist.
Yeah, well, I mean, that's so let me get this straight. So the state attorney general sat there and tried to influence local police, and at one point even attempted to flee to Mexico, supposedly her going on vacation, and just not show up. just for something that he knew, a crime that he didn't even commit.
That's right. That's right. Although, let me make it clear that they're going to Mexico. There wasn't an attempt to flee. They were on vacation. They came back eventually. They just didn't want to show up at trial because they knew there'd be a lot of media there.
Why not just reschedule the court date?
I could have done that, but I said there's a lot of people that gave up a lot of time to be here. This guy had a court date. He knew his lawyer was there. He just wasn't there. So I said, we can do everything that we had to do. It's not like I'm cheating him. He knew this date. He was given this date in court. If he hadn't been given the date in court, I definitely would have adjourned it. And I was trying to minimize the inconvenience to all the people that were here for the case.
Yeah. So the strange part is just it was just way too much after.
Too much about too little.
Well, nothing. Not even too little. It's nothing. So
Nothing.
right. So let me ask you. These are gonna be my last three last questions, but the biggest lesson you've learned about human nature as a judge and somebody who's worked in the judicial system for 40 plus years.
That there is always a story behind the story. Every case that came in front of me, well, I can't say every case, but many of the cases that came in front of me, it was just the tip of the iceberg. There was a whole history behind it.
Now, let me ask you this. If you had the choice, right, you were 20 years old again or 18 or whatever age, would you do it all again?
That's funny you say that because when we're on the tennis court, every once in a while someone will say, oh, if I was only 20 years old again. And I often comment, gee, I don't know that I want to go through it all again. But I mean, law school was very difficult. I wouldn't want to go through that again. I liked being a lawyer, but in the beginning it was very painful because you didn't really know anything. You didn't know the practical aspects of things. And every lawyer you talked to was more knowledgeable than you in the beginning. So that was a painful period. It's not a lot of fun negotiating fees with clients. It's not a lot of fun to come back from court and tell your client that you lost the case. Those are painful things. But I did like very much being a judge. And those painful things that I just told you about were prerequisites to getting to be a judge. So the answer is yes and no. I wouldn't want to go through some of it again, but I'm glad to go through a lot of it again.
Now, if you had any advice you would want to give to young people or just people in general, what would it be?
Well, two things. I tell the young lawyers, when I've had several young lawyers say to me, Judge, what advice would you give to a new lawyer? And my answer to that was read everything that comes in front of you. I used to tell the judges that every directive, every case, everything that comes in front of you, read it, be aware of it. You don't have to be really smart. You just have to be informed. The other thing I would say, and this is not something that I made up, this is not something original. I saw this on a sign in front of a library. Find people who will make you better. In other words, who you surround yourself with is who you're going to be.
I think that's fair.
Yeah.
As I like to say, the 5 people that you hang around with the most, it's who you are.
That's exactly right. Well, one other thing on that, George, another quote that I read was by John Wooden, the former UCLA basketball coach. And he would tell his players, concentrate more on your character than on your reputation, because your character is who you really are. Your reputation is who other people think you are.
Yeah, that's totally true.
Yep.
Any closing statements?
No, it's been a very fun interview, George. You do a good job.
Thank you so much. I appreciate having you on. I'm going to stop recording. I'll talk to you a little bit after the show, Your Honor. I thank you for your time.
Okay, good.